So it shows the webinar started and I don't see anybody. Here we go.
Yeah, it's working. Good morning, everyone. We'll be getting started promptly at 9 a.m.
Hi, good morning, everyone. Thank you for joining Schneiders and Associates Annual Employment Law Update 2023. We're happy you were able to join us this morning as our speakers Roy Schneider and Christopher Correa share with you the newest employment laws that will affect your business in 2023. Roy Schneider is a partner at Schneiders and Associates. Roy brings more than 40 years of experience to practicing law and is an employment law expert. Roy advises and represents companies and entrepreneurs with a broad range of business-related services. Christopher Correa is an employment law attorney and focuses primarily on defending employers against various wage and hour discrimination claims. Chris advises employers about their rights and obligations related to employment law. We're also joined this morning by Ashley Pope with the Ventura Chamber of Commerce. Schneiders and Associates is excited to once again partner with the Ventura Chamber of Commerce on the employment law update. And I'm going to turn this over to Ashley. She'd like to say a few words about the chamber.
Good morning, everyone. Thank you again for joining us. Thank you especially to Schneiders and Associates for doing this presentation for us every single year. I think moving to Zoom is a great move, and the fact that it's all recorded, we can pass this on and we'll pass this on. We appreciate you all being here, and we hope to see you at a future chamber event. We do have a mixer tomorrow at your CBD store on Telegraph at 5:30 p.m. I'm sorry, on telephone. So everyone is invited to come to that, and feel free to message us in the chat if you have any questions. Thank you.
Thank you, Ashley. Rory and Chris will be taking questions at the end of the presentation. Please feel free to type your general questions in the Q&A section, and they will answer some of those questions at the end. If you have a lengthy question or something specific to your business, please feel free to email your question to info@rstlegal.com. I will now turn things over to Roy Schneider, who will begin the presentation.
Well, thank you. Thank you, Ashley and Angela. Well, welcome everybody to our 2023 Employment Law Update. I'm Roy Schneider. We've been doing this for past 10 years, and we appreciate you joining us today, this morning. Fortunately, this year, the legislature sort of took a pity, I guess, on the employers and didn't go too overboard on employment laws. They probably beat up employers as much as they can for now, but the changes are significant, and they will require you to update your employment handbook and your policies. One of the strongest recommendations we have for our employer clients, of course, is to make sure they have an up-to-date, current, comprehensive, California-specific employee handbook. We can help you with that if you need help. Because that's a place to go. Whenever you have an employment question about leaves of absence and all other matters that may come up with the employees, often the answers are in the employee handbook. So that's why it's very important. And if employers ever get in trouble, the Department of Labor or the Labor Commissioner or the lawyers for employees will always take a look at the handbook. So we can't stress that enough. So we have new laws that you should talk about, and we will discuss them. Also, the PowerPoint will be available. You can contact Angela at the same email address that she gave you before, and we'll give you a copy of our PowerPoint. So, new wage and hour laws go in effect. As we know, they've been going up every year. They were supposed to top out at $15 an hour, but hey, I've moved up a little bit more than that because of inflation. It was $15 an hour plus the CPI. So for now, all employers pay $15.50 an hour as the minimum wage. We used to have a distinction between those with 26 or more employees, those under 25 or fewer, but now it's everybody. That's the minimum you pay. And overtime, of course, then becomes $23.25 an hour. So overtime is obviously a significant factor to consider. There are more than 30 California cities and counties that have minimum wages that exceed $15.50 an hour. There's a bunch. Cupertino is $16.40 an hour. El Cerrito $16.37 an hour. Los Angeles is $16.04, but $18.86 for large hotels. It's important to know those if you have employees work in other cities or counties besides Ventura County. And if they work more than 2 hours in one of those other places, then they're entitled to the higher minimum wage. So it's something to pay attention to. There's going to increase some of these 2023. Some cities and counties, they have their increases starting July 1. So you've got to pay attention to that. Also, this now affects these wage and minimum wage affects other things as well, such as what you have to pay an exempt employee. The advantages of an exempt employee, of course, are no overtime, no meals and rest breaks. But the exempt employees, they have to meet the test for exemption, difficult. This is problematic for a lot of companies. They may treat somebody as exempt when they're really not. People commonly use the terms hourly and salary. Those aren't really the proper terms. It's exempt or non-exempt. So to be exempt, you have to meet the exempt test, which is executive, professional, administrative, and they have to be paid a guaranteed salary, and it should be in writing, guaranteed minimum salary of $64,480. Even if they're part-time, You have a part-time CFO, you've got to pay him equivalent of $64,048 on a monthly basis. And if not, then they get overtime and meal breaks and all those other goodies. There's also, that's why classifying employees are important. You can imagine if you misclassify an employee as exempt when they're not, now you might have to go back and pay the overtime and meal breaks and less breaks. It could turn into tens of thousands of dollars plus all the penalties. So as prices go up for the employees, following the rules about exempt and non-exempt become more important. If you hire computer professionals, not just IT people, but programmers and other high-level computer people, they have to make about $112,000 a year to be exempt from overtime and rest breaks. And physicians that you hire by the hour, if you're a medical company, you got to pay them at least $97.99 per hour to be exempt. So there's rules like that. If you have those questions, you can contact us. But that's important. You should be aware of that. Well, this was interesting, kind of out of the blue to some extent, the Fast Food Accountability and Standards Recovery Act. This was aimed to improve the wages, hours, and working conditions of employees who work in fast food restaurants. And they describe them as chains. So it could be franchisors, franchisees, but if it's part of a chain with 100 or more nationwide, then they're subject to this act. This creates a fast food council, fast food workers council, made up of employers, employees, government people, various groups that are selected by the governor, non-elected group. They can set wages, hours, and working conditions for fast food employees. And they describe what a fast food restaurant is. We all kind of know that. And the law said that they can increase the minimum wage for 2023 for fast food workers to $22 an hour, and thereafter the lesser of 3.5% increase or CPI. So we'll go up. This will have obviously a huge impact on fast food prices and other industries as well. This will be considered by others as well, other companies as well. It is one of the first, it's consistent with some recent trends in our law dealing with industry-specific laws. The latest one that we had before this was the Garment Workers Protection Act that was enacted in 2021 and became effective this year, which basically makes the brand labels and the retailers liable for wage and hour violations of the independent contractors, the sweatshops that we have in this state. So that was a change. Now this is focusing on fast food restaurants. And what happened, interestingly, as you can imagine, the restaurant industry was not happy about this because that would increase their prices a lot. And this would then trickle around other restaurant type things as well, I'm sure. So the Save Local Restaurants Coalition, they first of all, within days after this act was enacted late last year, they got 10,000 signatures. They got enough signatures to put this on the ballot for November 2024. The state said, well, we're going to go ahead with this anyway. We're going to have our council. We're going to raise the minimum wage. We're going to change these working conditions for the workers because this doesn't go on the ballot till 2024. So they filed a lawsuit and the courts put this act on hold pending the votes in 2024. The law also protects workers in the fast food industry from filing complaints, from talking to medias, from protesting, from refusing to work in unsafe conditions. So it covers a lot. But right now it's on hold, and we'll see what happens as we go to the voters. So be prepared to be bombarded by ads pro and against this law, and I guess you'll have to decide whether you'll want to pay 25 cents or 30 cents more for your Big Mac in the future. So that's an interesting one, and you can kind of pay attention to that, and we'll see how things go. New act, and this is something you're going to have to update your policies about, and this is going to take some effort for a lot of companies. It's called the Pay Transparency Act. California has been moving in the direction of pay equity, pay fairness for a number of years. We're supposed to pay people who do similar work similarly, pay. This was to help women who have traditionally been lower paid than men People get to pay the same. You can pay difference if it's objective standards, such as certain education, certain experiences, and so on, as long as it's work-related. So we have that. And also you can't stop employees from discussing their wages with each other, so people know. This now, if you have 15 or more employees, and it's interesting how some of these laws are 15, some are 5, some are 50. This is 15. You have to include a pay scale for any position that you have a job posting for. So if you go on LinkedIn or Indeed, or you put stuff in the community colleges on their placement offices, looking for jobs, you have to have a pay scale. Many times we don't have pay scales, right? You have an opening and you interview some people and you see what the market price is, what things are, or how much you can afford to pay this person, and they come up with a pay. Now you have to post a pay scale. Also, if any employee asks you, what's the pay scale for my position, you have to tell them. And my guess is for small employers with 15, 20, 25 employees, you've never had a pay scale. And someone's going to ask, what's my pay scale? You don't know. If you don't have pay scales, you don't properly answer this, there is fines. It's actually unlawful, and the fines can be up to $10,000. It's a lot. Now that the Department of Fair Employment and Housing, or the Civil Rights Commission we have now, they're not going to fine you for the first violation, but they will after that. So it is pretty important they do this. Plus, all employees of all sizes have to keep records of job titles and wage rate histories of their employees for 3 years after termination. And so I'm not sure all your employees have job titles, but you have to write that down. We get the title, wage rate history, and those are important. So this is really key, and we can help you with that if you need it, but these pay scales are critical. And it's to help, again, pay equity. So somebody applying for a job knows, gee, people with this position make between $17 and $20 an hour, between 20 and 22, and it helps prevent some equity. But this is important, so you really need to work on that. Plus, there's now some pay data requirements, pay data reporting. This doesn't apply to many people in Ventura County, but if you have 100 or more employees, you're used to doing this. So if you file with the California Civil Rights Department, we used to call it California Department of Fair Employment and Housing. I'm still stuck with that term, but it's a new division now, new department. But now you have to add, in addition to your normal report, the mean and median wages for your employees based upon categories of race, ethnicity, and sex for each job category. Now, since we can't ever ask anybody what their race, ethnicity, or sex is, I think this could be difficult, but you have to do the best you can to point out what the wages are for the different groups. Again, and this big effort for fairness and equity in payments for people. There's been lots of talk in the past regarding agricultural workers and the disadvantages they've had and so on. So they're trying to make it a little bit easier, maybe, for them to unionize for farm labor contractors, for farm labor workers. But we're going to leave it up to the employer to decide which way to go. So if your employees want to unionize, or there's union discussions, if you are in an agricultural business, the employers can agree to what they call a labor peace compact. That means the employees can now vote by mail ballots. Now, before this law, the only way they could vote for unionize was secret ballots at the place of employment. And the employers could have captive meetings with their employees. They could talk about the pros and cons of unionizing, why unionizing is not good for them, why their employees are better off with the current policies. They can even discuss why one union might be better than another union. You can do that. Plus, going to the place of business to vote could be a little bit sometimes oppressive. There could be intimidation. So that was a problem. So employers can have this peace compact, but employees can vote by mail, and employers cannot hold these employee meetings. They can talk truthfully about the benefits and policies of their company, but they can't contrast it with unions. They can't even reference unions. So if you're in this kind of position, you need to tread carefully. Or the employer can decide that the workers can unionize simply by submitting authorization cards. That's easy in a way for the employees. They just sign these cards. You get 51% to do a card check. They just sign a card, I want to unionize, and the union now is the representative for the workers. But during this process, the employers are free to hold meetings like they could in the past and talk about the pros and cons of being in the union and so on. So this is for the employers to consider. And if you are in this situation, you want to make sure you tread carefully and do this accurately. We haven't raised mileage in a while, mileage rates for people. And in July, they usually raise them in July. So we're going to see what happens in July of this year. But it's now 62.5 cents per mile. That's what you're supposed to reimburse your employees at, which is kind of interesting. And we'll see what happens. What you may want to do if you have employees driving around for you in their own vehicles, instead of keeping logs, what a lot of companies do is they just give an auto allowance. So you can give $150, $200 a month, and then you don't have to keep such track. As long as the amount you give kind of coincides with the average kind of mileage and stuff that they drive. So that's something to think about. Otherwise, keep in mind, reimbursement is now 62.5 cents per mile, which is up, which is interesting. So we'll see what happens in July of this year. This is a confusing area, one where there has been a lot of lawsuits and claims, and it's a difficult one. And there are different laws. There's laws dealing with taking care of your relatives. There's federal law, there's state law, there's sick leave, bunch of stuff all comes into this thing. So, but you're all familiar with the California Family Rights Act, or you might be. That now covers 5 employees or more. So that covers a lot of companies. And there's also the Healthy Workplaces, Healthy Families Act, which deals with sick pay, and that's any size employer. So the Civil Rights, California Family Rights Act, this was the list of people that you could take 12 weeks of unpaid leave to care for. There's a list of people. Not on that list, you could not take time off to care for these people. But beginning January of this year, employees can also take leave, 12 weeks of unpaid leave for 5 or more employees, to take care of these people or a designated person. And a designated person is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. Now that is not really defined. It's in there because about 19% of households are not made up of nuclear families. There are people who live together and have developed sort of a family relationship. And so those people can be designated. You can designate the person when you're ready to take the leave, and you can limit, employers can limit employees to 1 designated person for 12-month period. So it's interesting about that. And we'll talk about that in a second. And you can use up to half of your accrued paid sick leave to care for a designated person. So that is a different sort of law. It's not in the California Rights Act, but it's all part of the same, statutory scheme. So if, right now in California, you get 24 hours of paid sick leave, that's guaranteed. You could take 12 hours to care for the list of people I showed you, or this designated person, and even more. We'll see that in a second. So if you give your company gives 10 days of paid sick leave, then they can take up to 5 to care for someone else. We'll see that. Then that ties in with the Healthy Worker, Healthy Families Act, which is your sick leave time. And that has a different definition for designated person. So in the California Family Rights Act, it is somebody who is related by blood or has a family relationship. The Healthy Workers, Healthy Families Act, to take off your sick time to care for somebody else, it can be anyone you designate. It can be your daughter's boyfriend's cousin. It can be your neighbor, anybody you want. You designate who they are, but the employer can ask for some evidence of the person is ill, needs care, and you can get paid for half that time. Now this law kind of conflicts with, let's finish this. There's the Kin Care Act, and this is 24 hours. That's how they tie in together. They're all very close in the labor code, but this is where we get 24 hours required. you might give 5 days or 10 days or 7 days. You got to keep that in mind, and then you can have to pay half that time for them to care for somebody else. What's interesting is this now doesn't actually sync with the federal Family Medical Leave Act that we have. There, if you have 50 employees, as you know, the Federal Family Leave Act, you can take care of yourself or a list of people, kind of like the list I first showed you. If people are on that list, you can take time off, 12 weeks, unpaid leave to care for them. And traditionally, California Family Rights Act leaves and federal Family Medical Leave, they rank concurrently. But now they have different people. So for example, you have an uncle who gets ill. Well, he's not one of the designated people on the federal law. So you could, but he is under California. So you can take 12 weeks off to take care of your uncle. At the end of the 12 weeks, your father gets ill. Then the employee can take 12 weeks off to care for his father under the Federal Medical Leave Act, Family Medical Leave Act, because that father is one of the listed persons. So this is kind of confusing. You do need to get advice if you're concerned about it, but these things are what should be in your handbook. This is why we have a handbook to distinguish between all these rights and so on, how many employees. And keep in mind that you could have 13 employees today, and by April have 15 employees, and now you're going to be bound by that designated person rule. You're going to have 47 employees, and before you know it, be 50. So you've got to pay attention. You got to see what is involved, so you keep current on these things. So now I'm going to turn this over to Chris, who's going to talk about some more laws, and then we'll get into some cases.
Good morning, thank you. And moving on from the Kin Care and Family Care Act and the persons you can take your sick leave to care for, let's move on to, unfortunately, let's hope it's not the next step, but bereavement leave is now becoming a law that applies to any employer with 5 or more employees in the public sector. In order to be eligible for bereavement leave, the employee must have been employed with the same employer for at least 30 days prior to starting the leave. They may take up to 5 days of bereavement leave upon the death of a family member. This definition still includes the traditional spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. The leave can be unpaid. In other words, employers are not required to pay for the leave. However, employees can use existing leave available to the employee. Others, they have accrued vacation, or if they do have some of their sick leave time left over. It must be completed, the bereavement leave must be completed within 3 months of the family member's death. And while it might not be advisable, if there's some reason to suspect that this is not a truth or trustworthy employee, you can require supporting documentation that a death did in fact occur. So that is one new section that should be updated in your employment policies or added to your existing handbooks. That's something you definitely need to put in there, because now bereavement leave is the real thing, and you don't want to be dancing on your toes to figure out the correct law at this current time while someone's dealing with a trauma or a death in the family. Now, moving on to reproductive health drugs and contraception or abortion. This is known as the Contraceptive Equity Act of 2022. And that makes California's birth control benefits gender inclusive and requires coverage of over-the-counter birth control options, vasectomy services, and clarifies that employers in California may not discriminate or retaliate against their employees based on their personal contraceptive or reproductive health decisions. Now, this is a little bit or significant 180-degree turn from how it used to be. Originally, the FEHA was designed to prohibit employers from discriminating against an applicant, typically a female, who was undesirable because it was likely that she, quote, get pregnant and leave the company to raise kids. Now it's kind of turning around. So if your employee or applicant does not wish to have a child, you cannot discriminate against him or her for doing that. So again, this act, the Contraceptive Equity Act, expands the FEHA, making it unlawful to discriminate against any employee or applicant based upon their reproductive health decision making. Anyway, so that includes access to drugs, morning after pills, things like that, any specific product or medical service related to reproductive health. And that again became effective January 1st of this year. Moving on to another ever evolving topic in California and other states is AB 2188, which now prohibits employers from discriminating against people who use cannabis or marijuana away from the job and during non-working hours. So what that means is you need to take a look at your drug screening processes and your drug testing processes if you have any in place for both applicants and employees. Because now, or let me rephrase that. In the past, the test would typically show any presence of THC metabolites, which means the person could have consumed THC or marijuana at a prior time, but still have the metabolites broken down in their system show up on a drug test. These are called presumptive tests in some places. If you have drug tests that were purchased more than 2 years ago, pre-COVID, things like that, you may want to update those tests. The law does not prohibit you from using a test that will define or determine whether or not a person could be impaired, because it identifies the actual element that causes the psychoactive effect, the THC. That drug test would be advisable, and it's really the only one that you'll be able to use to test employees for the presence of THC if you believe that they are impaired while at work. You need to, again, revise your existing drug policies, or if not the policies, update your testing kits and make sure that they're compliant with this new law. Again, it won't be implemented, it won't be implemented until January 1st, 2024, so next year, but you should get on this now, because I think there's going to be some bumps in the road to get a test that's affordable and reliable. Again, the law does not permit employees to use, possess, or be impaired by marijuana on the job, and it does not alter your drug-free workplace policies. So another issue, like I said, that there's going to be some bumps in the road, is impairment is not defined. So that could be litigated. Brief aside, if you talk to a drug expert, he or she will testify typically that the effects of marijuana last 45 to 60 minutes. So to determine whether or not someone's impaired, these tests are going to have to be quite accurate. And I think it's an area that's going to be litigated as this becomes more of an issue. It does not apply, AB 2188 does not apply to building and construction trades. And the law does not apply to employees who are required to be tested as a condition of employment prior to receiving federal funding or licensing benefits or entering into a federal contract. Employees subject to a federal background check are excluded from AB 2188. In other words, marijuana is still prohibited on a federal level. So anyone that's getting funding or working for the federal government can still have a strict no marijuana use policy that can be enforced, and an employer applicant cannot have a cause of action against a federal employer. And once again, this does not become effective until January of next year. So again, update those policies. Now, one thing that is popping up, it's always been meal and rest breaks lumped together. When I see these lawsuits, it's always meal breaks, rest breaks. I rarely see a lawsuit that does not contain both meal and rest break allegations. However, now attorneys are getting creative, these plaintiffs are getting creative, and as you probably know, rest breaks are not typically recorded by timekeeping software because they're compensable time. The employees are paid for their 10-minute rest breaks every 4 hours. So typically, there aren't records. Whereas when you go to your 30-minute lunch, someone clocks out at 11 o'clock and they come back at 11:30 or 11:31, you have evidence from the punch outs that they took their full uninterrupted 30-minute meal period. This arose from a case where a phlebotomist filed a class action claim against Quest Diagnostics, claiming that the productivity goals of Quest were such that they prevented the employees, the phlebotomists, from taking their duty-free and uninterrupted 10-minute rest period. Now, again, it states that the IWC, the Industrial Wage Commission, states that employers shall authorize and permit all employees to take rest periods. Interestingly, the IWC does not include the words duty-free or uninterrupted. Again, more room for litigation. Specific to this case or this claim with the phlebotomists is that the amount of time that it took to draw blood for each of the 24 to 30 patients these people would see per day was mathematically limited their ability to take an uninterrupted 10-minute break. So that was able to be established by the time it takes to draw blood from people, and this claim had some legs. Now, that's sort of the factual background of the factual basis. This is an unpublished opinion, but the issue that the court focused on in Quest is whether or not the policy that applied to all potential class members was suitable for class treatment. The court found that this was suitable for class treatment because all these phlebotomists had the same productivity requirements. They all had to draw blood from 24 to 30 patients per shift. And so therefore, the court said if the employer's expectations are such that it's impossible to demonstrate that the employees can take the uninterrupted duty-free 10-minute rest break, the court's going to determine that the plaintiff has a common question of law and therefore it's suitable for class treatment. So how does this apply to you? Well, if your business has a policy or policies for its different divisions that requires employees to meet certain goals during their shifts, productivity, typically, a number of objects or widgets that need to be made, you need to make sure that you include a clear articulated carve out for the applicable 10-minute rest breaks. So again, my favorite employers or my favorite employers to defend cases on meal and rest break claims are those of the bell system. That's not practical in a majority of employers' businesses. However, in addition to that lunch bell that would ring and then ring at the end of the 30-minute lunch period, you could have something similar to that programmed into, if you have a bell system or a computer system or some other way, to have a manager notify these people to stop what they're doing and take their 10-minute rest break. Again, down at the bottom, the analogy would be, you require your employees to sew 100 pair of pants or build 100 widgets each shift. You need to make sure that there's enough time to carve out 2 10-minute rest breaks if they're working 8-hour days in that shift. Now, beginning just past here on January 1st of this year, employers are no longer obligated or required to provide paid COVID-19 sick leave. You're also not required to provide employees with second or third COVID-19 tests. This is different from under the 2022 rules and before, because employers were permitted to request a positive test and a second test 5 days after the initial test. The second test had to be provided to the employee at no cost to him or her, and employers were also required to offer a third COVID test within 24 hours of the positive second test, again at no cost to the employee. I know that's a mouthful, but essentially your obligations have been relaxed as far as the testing and the requirement to provide tests for your employees. Similarly, or under similar legislation 8152, you have the COVID-19 Relief Grant Program. Now, this is to help small businesses and nonprofits that had to bear the cost of this supplemental paid sick leave, the 80 hours of paid sick leave for the employees, who almost all of them used it through one way or another, themselves, caring for others, or exposures. The grant applies to all employees who took supplemental paid sick leave during the year of 2022, this is specific to last year, and qualified employers can recover up to $50,000. In order to recover that money or a portion of that $50,000, employers must satisfy all or each of the following requirements. They must be a C Corp, an S Corp, an LLC, an L.L.P, a cooperative, partnership, or registered as a 501c3, 501c6, 501c19, you're nonprofits essentially. Those are the people that's what employers will qualify. They must have been in operation before June 1st of 2021, so 6 months before the law or before the operative period of 2022. They must still currently be open and operating, and they must employ 26 to 49 employees. Again, the numbers of employees are very, there's no continuity. It's 5, it's 15, it's 26 to 49, it's over 50, but this particular one applies to small businesses and nonprofits, 26 to 49 employees. You employers have until January 1st of next year to qualify for the grant, and if you think you qualify or are eligible for the grant relief program, you need to go to the California Governor's Office of Business and Economic Development. They gave it a quirky acronym or a cute acronym of GoBiz, and that's the agency that's going to help the employer provide and obtain and then therefore turn in and provide the required documentation. Similarly, the notice requirements about possible COVID exposure in the workplace have been relaxed, I guess we can say. AB 2693 extends your obligation. You still must notify employees about a possible COVID-19 exposure at the workplace through the end of this year, through January 1st, 2024. However, this new law eliminates your requirement to notify the local health department. That was at time burdensome, especially at the peaks when you couldn't get through. It also permits employers to post a notice of possible workplace exposure instead of issuing the individual written notices to each employee. Again, another thing that was quite burdensome on HR and admin employees, especially for employers with a large number of employees. The posting, and again, one posting instead of individual notices must contain the dates on which an employee with a confirmed COVID case was at the workplace, the location of the exposure, and contact information must be available for employees to receive COVID-19 related benefits, such as workers' comp, leave time, your own personal employer's sick leave policy, state mandated leave, and supplemental leave, as well as any anti-retaliation protection for taking leave for COVID-19 related issues. And there also must be contact information available for the employee so he or she can determine or request to find out what the employer's cleaning and disinfection plans are for when COVID is exposed, or when persons in the workplace are exposed to COVID-19. Again, most of these leave provisions will expire at the end of this year, but as employers, you still have a right. Some people still have or will continue to have COVID-19 sick leave policies for your employees and your businesses, which is perfectly okay. This is just what's telling you it's now a more relaxed standard. Well, interestingly enough, this is a very, very niche, unique carve out in this updated law or change in the law. But now janitorial employees are back to being required to attend sexual harassment training every other year, and it must be in person. During COVID-19, in order to keep other employees as well as the janitorial staff healthy and safe and not contracting or passing along COVID-19, they were allowed to obtain the certification and attend the trainings online. Well, that's going to be lifted, and now the in-person training requirements that have been effective as of 2019 will be back in order effective January 1st of this year. So now you must begin complying with that if your business involves janitorial employees. All right, a lot of you know, if you've had your handbooks done by us or anyone else, we always ask you what holidays are observed by the businesses. And for a long time, it's been 11 holidays in the state that the state of California has recognized. There's a list of them up there. You can probably name most of them off, and a lot of you honor at least a portion of these, if not all. Again, those are the dates this year that the 11 state holidays fall on. And now, in addition to those 11, I'll give you a moment to read through there again. Nothing new. We're getting there, though. In addition to these 11, we now have 4 new California state holidays. So as of January 1st of this year, they added the Lunar New Year, which just passed this past Sunday. It's the year of the rabbit. The Lunar New Year was formerly known as, or is also known as, the Chinese New Year. You have Genocide Remembrance Day, which is to commemorate the victims of the Armenian Genocide from 1915. Juneteenth will be observed on Monday, June 19th. And Native American Day will be observed on Friday, September 22nd. So now you're up to 15 state holidays in California. However, while these state holidays exist, you're not required to pay employees for these holidays. So if you give them the day off and they don't work, you close the office or the business on that particular holiday, you're not required to pay the employees for those holidays. And if you choose to pay them, you do not have to pay them. If you choose to stay open and therefore they're working, you don't have to pay them a premium or a higher rate. They don't get time and a half or double time because they're working on Christmas or New Year's or the Lunar New Year. And then if they are working on those holidays, regular overtime and meal respite rules are still in effect. So they still have to take their 2 10-minute rest breaks for an 8-hour shift, as well as their uninterrupted 30-minute meal period. Now we have the CPRA, or the California Privacy Rights Act, which has been around and applied mostly to businesses when you're in the capacity of a consumer. However, it's extended its applicability to employers, which include for-profit companies doing business in California and collecting personal information of California residents. In most cases, especially for those of you watching this program, you and your employees are California residents. In addition to that, you have to meet certain criteria for size, including, for example, over $25 million in global annual revenue. $25 million isn't what it used to be. So, this could apply to some of us here, but the point is that if you're collecting data that contains your employees' personal private information, you have the same requirements and the employees have the same rights as a consumer. So when you don't want to give up your personal information, when you fill out a gift card or an app or a promotions program at a grocery store or a retail outlet, and because you don't want your information sold, your home address, your telephone number, your email address, those are starting to expand and cover employees now. So what do you have to do as the employer? You have to post privacy policies about how your human resources data is handled. You have to comply with the new rights regarding the data, which includes deleting it, getting corrected copies of it, and also obtaining specific copies of personal information. And then you also must include the CPRA provisions in contracts with vendors that handle HR data. So in other words, if you have an outside vendor that handles your HR, you're a small business, or you run a business where employees are out and about, not necessarily in the workplace at all times. So you have an outside, perhaps, I don't know, Paychecks or one of the major payroll companies oftentimes offers HR services. Anyway, if you have an outside HR company handling your human resources data, you have to put the provisions in the contracts with those parties to make sure that they handle and maintain and get rid of or properly secure the personal information contained in your employees' human resources data. All right, shifting over to some workplace safety. I thought this was common sense, but now we're turning common sense into law. SB 44 is a new law that prohibits employers from, in the event of emergency condition, from threatening to take adverse employment action against the employee for refusing to report to or leave a workplace because the employee has a reasonable belief that the workplace is unsafe. Again, that's a mouthful, but the emergency condition is defined as a disaster or extreme peril to the safety of persons or property at the workplace or worksite caused by either natural forces or a criminal act. Again, if you're under attack, or if there's a tornado or a cyclone bomb, is that what we got hit with a couple weeks ago? Feel free to use your cell phone and not be worried about your employer taking adverse employment actions for breaking their personal cell phone use policy. In order to evacuate a workplace, a work site, or the worker's home, or the school of a worker's child due to a natural disaster or criminal act. So in other words, anytime there's again, it's unfortunate that it's more prevalent, but anytime there's an incident at a school or a workplace, usually domestic things pour over, or you have your shooting incidents that pop up much too often. Again, this would obviously qualify for one of those situations. Probably a mouthful and probably common sense. All of you are going to call and take care of yourselves, your loved ones, and your children in the event of this. But now you need not worry about being retaliated against by your employer for doing so. A less hot button topic, but now there's additional OSHA requirements that require you as employers to post OSHA information regarding citations or orders in English and in other languages. So in the past, you might have a workplace incident where an employee or employees were injured and you receive what's called either a citation or a notice of intent to cite. And typically those are handled by the brass of the HR or whoever's in charge of workplace safety in your particular location. But now what's required, and typically they were in English, oftentimes they were in English only. Now there's a requirement that Cal OSHA information must be posted in the workplace in multiple different languages. So if you have a workforce that speaks another language other than English as their first language, you need to post both Spanish, Chinese, any other language besides English, in addition to the English postings in the workplace where they're visible and accessible to employees. Cal OSHA is responsible for drafting the alternate language notices, so that's not your burden. So again, they must be posted in the same places as the English notices as well. And they must be placed in the same place where the English notices are, and that includes where the violation referred to occurred. So if someone had an accident in the warehouse, the postings must be in the warehouse, not in the break room for the admin employees, things of that nature. And you can find all these posters for OSHA at OSHA's website, which is, I believe, osha.gov or calosha.gov. And it's usually a PDF link, so you can print those out and post them as needed. And again, if you get the citation or the notice of intent to cite, CalOSHA is required to provide it in both languages, but you have the duty or burden to notify them that you need it in different languages than just English. All right, more benefits for employees here, which is the Cal Savers Retirement Program. So as you may know, as of last year in July, employers were required to offer retirement benefit plans to their employees. So if you didn't have a 401k plan, for example, then your other option was to offer them a Cal Savers program. And the new law for 2023, you'll have to have this all in order by December 31st of 2025, but you are required as of now to have a retirement plan in place. So this expands the definition of eligible employer to a person or entity with as little as one employee. This used to be 5. Again, these numbers are changing. But if you just have one employee working in your office, you're a solo practitioner, you just have a secretary that answers phone calls or an assistant that helps you with admin work. All it takes is one employee, and you're obligated to provide a retirement plan. It's no longer the five employee threshold. It excludes business entities. If you just work by yourself, you're your only employee, you're the only person in the building, you're the only person on the payroll, you do not have to offer yourself a Cal Savers or a 401k plan. Eligible employers that do not offer their own employer-sponsored retirement savings program, like a 401k, must have a payroll deposit retirement savings arrangement in place by December 31st of 2025, so that employees are able to participate in Cal Savers. Again, if you have questions, this is, I won't say it's straightforward. If you have a 401k plan, you can kind of gloss over this. If you don't, and you can't afford that or don't want to do that because of the size of your business, you now have to have some option for that, as little as one employee or employees that you have working for you. Moving on to another law, which is, again, I would say somewhat of a trend in recent years from the Me Too movement and on, is the statute of limitations for sexual assault claims in the workplace has been extended. So AB 2777 revives the claims seeking to recover damages suffered as a result of a sexual assault that occurred on or after January 1st, 2009. So that would, those would usually, well, I shouldn't say usually, let me rephrase that. A majority of the sexual assault criminal violations, some don't have statute of limitations, some have 8-year statute of limitations, some go up till the victim turns the age of 40 years old. So, but there's also misdemeanor charges, and those have typically a 1-year statute of limitations. There's also some, I believe there's still some 3-year statute of limitations for sexual assault crimes. Anyway, this law allows employees who suffered a sexual assault through their workplace or at their workplace to go ahead and go back and still file an active claim. It revives the claim seeking to recover damages suffered from sexual assault that occurred on or after the plaintiff's 18th birthday, when one or more entities are legally responsible for damages because they engaged in a cover-up. So that's unique. That's showing that the employer covered this up. They gave hush money. This is why you can no longer have non-disclosure clauses related to sexual assault. This is a similar thing because people would write a check, or employers or entities would write a check to cover up this issue and basically put a gag on the victim. So those days are over. If the person has not filed an action before January 1st of 2023, in other words, if you were an employee who fell under this category, unfortunately, and you'd not filed a claim prior to January 1st of this year, you must file that action sometime in the year 2023. In other words, if you were a victim of a sexual assault as far back as 2009, but have never filed a claim or made a claim, you must commence that action beginning January 1st of this year through the end of this year in order for this to apply. So let me shift over to Roy for our new case law, and I'll talk to you in a few more minutes here.
Okay, well, thank you, Chris. There was a lot to cover. I hope your brains aren't spinning around in your head too much, but as I said before, we will make these slides available for you so you can review them slowly at your leisure, and certainly call us with any questions or email us with questions that you might have other than the questions you might post for us here. Interesting cases. This is fascinating. The seat law. Most of you, or maybe all of you, don't know that California has a seat law. It's part of a wage order 7 for those in the mercantile business or who has office, clerical workers, professional workers. It's in the wage order that you have posted in your break rooms that nobody ever reads. But there's a seat law in California. And it states that if a job can accommodate a seat, you must provide a seat for that job. If the job doesn't accommodate a seat, you must provide seats close enough by where the workers are so they can sit down if they want to. There is no definition of what close enough by is. Some have said that you have to have seats so that employee can sit down and at least see where their work area is. So you have to provide seats. And there have been lots of suits based on this, different Target and other places where there's the cashiers and so on, and there's questions whether that job really accommodates a seat because they got to lean over and so on. But this was AutoZone, big company that and they probably weren't aware of this. People at the counter could easily sit down. They did not provide seats for people at the counter. So they bought a suit. And actually, there was enough of people to bring a class action that they violated the suitable seating requirements. And AutoZone said, no, we have chairs around, and that they may have, but they never made it clear to the employees that those chairs are for them to sit on if they need to, and or that they could be moved over to their workstation, to the desks, or into the counters. So there was enough to get past summary judgment claims, and now it's going to go to trial by discreet employees. So it's interesting. It's a lot of facts involved, whether the seats were really available, whether they were close enough by, how they were handled. So look at your workplace and see if the job can accommodate sitting. If it does, provide a seat. If not, make sure you have chairs close by around the place, and employees know that those chairs are for them to use if they want to. That's a big case. So be aware of that. Yeah, so here you go. That's what it says. So you need to pay attention to your seating policies and even have a policy, and maybe put it in the handbook. That's what you do if you're in that kind of a business, mercantile, your restaurants, retail, professionals, clerical, kind of interesting. So pay attention to that one.
Yes, that's another one of these common sense things. The plaintiff in that case even knew that the chairs existed and were available right near the manager's office, but she didn't pick up that chair and file the claim and prevailed. So anyway, moving on to another one, and it's a little more technical, but this is Lene versus Lowe's initially, but she appealed. The plaintiff and four other individuals filed similar actions under PAGA, the Private Attorney General's Act, and they were consolidated. The employer, Lowe's, argued that the PAGA actions, these four, should be stayed pending the outcome of over 50 other similar matters that were currently in arbitration. The trial court granted the stay pursuant to a code section that required a stay of any arbitration of controversy which an issue is involved in the action. In other words, if you're arguing over the same claims, I didn't get my meal breaks, they must be stayed under that code section. The trial court specifically found that the statute focuses on the issue rather than the parties. So if everyone's claiming meal breaks, for example, then the issue was what the focus was. Lene and her attorneys filed a petition for a writ of mandate directing the trial court to vacate the order. The California Court of Appeals agreed with the plaintiff and directed the court to vacate the stay, finding that the plain language of the statute requires a pending action involve both the arbitrable question and the parties in the arbitration. Because Lene and her co-PAGA plaintiffs, the other four, the subsequent four, were not parties to the initial 50 pending arbitrations, it did not authorize a stay on the claim. So what's the lesson? Again, it's somewhat technical, but in order to successfully stay the representative class action or PAGA action, in this case under PAGA, the same issue and the same parties must be involved. Again, Lene and her 3 other co-plaintiffs were not involved in 50 art cases that were already in arbitration. Just a side note, again, I'm on the defense side, so I look into this with the Viking River Cruise case, which the Supreme Court had offered the opinion that the FAA requires enforcement of an arbitration agreement that waives an employee's right to bring an individual claim through the PAGA, because once the individual claims are sent to arbitration, there is no standing for a representative claim for violations of the California Labor Code. Again, a little bit technical, but you got to focus on both the issue and the parties that are involved. It's not one or the other. Meal breaks being the common claim is not enough. The parties or the individual plaintiffs also have to be identical. Moving on to another case that I'm going to refer to as the Prime Healthcare. I think it might be Gavri Igloglu, but the Prime Healthcare case, similar, or not similar, but along the same lines, parties must be acting in the same capacity in order for issue preclusion or claim preclusion. So in this case, the plaintiff filed claims under alleging violations of the California Labor Code under PAGA, again, a class representative action, PAGA action. And she also filed causes of action that fell under the FEHA, the Fair Employment and Housing Act. They had valid arbitration agreements. So again, the non-PAGA claims, the discrimination or wrongful termination claims were sent to arbitration. The arbitrator ruled in favor of the employer, ruled in favor of Prime Healthcare Management, finding that no labor code violations occurred. And talk about a win, but in a rare instance, they found in favor that no labor code violations occurred. The employer was ecstatic, and so then they filed a motion for judgment on the pleadings as of the PAGA claim, alleging that the plaintiff lacked standing because, as a result of the arbitrator's ruling, she was not a, quote, aggrieved employee, end quote, as a matter of issue preclusion. The trial court, again, I don't think they read too deep into this. It seems like an error on its face, but they granted the defendant employer's motion without leave to amend, and the plaintiff appealed. Again, the appellate court found the trial court erred in basing its decision on issue preclusion and reversed the decision. California, we have a rule here that the identity of in order for the identity of the parties to be satisfied for invocation of issue preclusion, the party must be acting in the same capacity. Again, the ruling by the arbitrator was only to the labor code violations, the meal and rest breaks, the overtime claims. It had nothing to do, right? No bearing or no determination on the outcome of the non-PAGA claims. So again, the court reasoned that the plaintiff was litigating in her own individual right to damages for labor code violation and was litigating the state's right to statutory penalties for labor code violations. Therefore, the ruling did not have a preclusive effect on the other claims. Again, what's the lesson to you employers out there? When you're dealing with the California Labor Code and the PAGA, even when you win, you still lose. There's an argument that this case would be distinguishable if the plaintiff was litigating an individual PAGA claim, because if she'd been an individual PAGA claim, the Viking Cruise Line case that we mentioned a moment ago would have precluded her PAGA claim if it was as an individual. Again, a mouthful, but because she had a representative class, it was more than just Ms. Gabrielle's claim herself. All right, and then we have the Camp versus Home Depot USA case, which is, if you guys are, if you recall, there was a See's Candy case on rounding, and some employers and some timekeeping software have a rounding system that is still legal in California as long as the rounding is not, as long as it's applied equally and not unfairly applied to the employee or to the employer's benefit. In the Home Depot case, as you can imagine, a company like Home Depot, they're not doing punch cards or handwritten time cards. They're using elaborate software. These guys have the equivalent of an iPhone in their hand. They can find anything in the store at any time. Similarly, they can log their time and use the software to clock in and clock out. So some of you may use this, some of the employers I've defended have used it. They have the Chronos timekeeping software, which records the exact minute. If I recall it, records the exact second as well that the employee punches in or out for his or her shift, or leaves for their lunch break and then returns from their lunch break. However, Home Depot, in addition to having this very specific timekeeping software, still use the quarter-hour rounding system for the employee's total shift time. So Mr. Camp or Ms. Camp filed a class action claim alleging unpaid wages as a result of the rounding policy. Home Depot moved for summary judgment, arguing that the rounding policy were complied with or didn't violate the See's Candy ruling, which required that the policy be neutral on its face and neutral as applied. Again, they did that. Home Depot did that. The trial court agreed and granted the motion. Camp appealed. Court of Appeals reversed, relying on two other recent Supreme Court cases, California Supreme Court cases. That's the Troster versus Starbucks and Donahue versus AMN Services. In those two cases, the California Supreme Court ruled that the labor code and the wage orders mandate that employees are paid for all work performed. So again, the lesson to you is there are advancements in technology that now are permitting you to track the exact amount of time an employee is working. So if you have software, if your business uses software similar to Kronos or any of these other ones that have specific time punches, 12:01 and 13 seconds, 12:32 and 17 seconds, you should not have a rounding policy in place. Get rid of the rounding policy. I won't tell you to get rid of the software, but that's another option. But if you have software that tracks the exact time, you can't have a rounding policy. Again, just without getting too technical, the decision didn't overrule the See's Candy case. As I've mentioned a couple times now, you can still have the rounding policy, but if you have timekeeping software that captures the exact amount of time of employee's shift, those employees must be paid for all hours worked down to the minute, and you can't have a rounding policy there. And I'll give it back over to Roy for one more dose of case law.
Couple more cases. Yeah, we usually don't recommend rounding. We think it's best for employers to just pay for the hours worked. Rounding can just lead into problems and trouble. So it's best to just pay for the hours worked and not round up or down, even though it may seem fair. Arbitration is a big issue here. Employees prefer to go to court when they have a claim, especially for discrimination and retaliation, because they like juries. And you can get the runaway juries because most jurors are employees and they rule in favor of employees. Employers prefer arbitration by and large because one, it's private, it's not a public matter like courts are. And arbitrators are not as sympathetic as jurors might be. Plus most arbitrators have come from the employer class before they became arbitrators. So it's an issue. And California actually passed a law a little while ago, that employers may not compel arbitration provisions as a condition of employment. You cannot require an employee to arbitrate as a condition of employment. However, there was a case where they did, and the employee had a claim and filed arbitration. And the employer filed a lawsuit, and the employer said, no, we got to arbitrate this. Employer said, no, you violated California law. You made me sign this. Well, went up to the appellate courts, and appellate court said, no, the Federal Arbitration Act governs. The Federal Arbitration Act says state law cannot prohibit or interfere with the arbitration, and this doesn't. So you violated California law, so what? Once you sign the arbitration agreement, now the arbitration will govern under the federal acts. So if you have arbitration, you want arbitration for your employees, talk to us or talk to other lawyers about how best to do that. But in this case, very interesting, California viewed this. This was an employee retaliation case, filed a lawsuit, and they had signed a valid arbitration agreement. Apparently weren't coerced, wasn't a condition. They signed, it was valid, and it was being governed by the California Arbitration Association to do it. The CAA requires defendants, which is the employer, to pay its share of the arbitration fee at a certain time, within 30 days of the due date. Wood Ranch was 6 days late, and the plaintiff moved to vacate the order compelling arbitration. Wood Ranch appealed, claiming the Federal Arbitration Act preempted the California Association arbitration. The appellate court agreed with the trial court, holding that the Federal Arbitration Act only preempts state laws that discourage or prohibit arbitration, which it did not. The employer was just 6 days late in paying the fee, therefore lost its ability to arbitrate and had to end up litigating the case, which, as I said before, usually isn't favorable for the employer. So the lesson here, of course, pay your fees on time. So if you have arbitration agreements and there are claims or lawsuits filed by your employees and you want to pursue your arbitration remedy, get advice, get legal advice, come see us, make sure you do it exactly right. Cross all your T's, dot all your I's, or you will end up litigating. Now, this is also interesting in California. So this is a company with a call center. And the basic law in California is you're supposed to be paid anytime you're doing something integral and indispensable to your job, and employers still have some control over you. So employees had to boot up their computers for the call center, and they would clock in, and they'd have to turn on, boot up their computers, and it took 6.8 to 12.1 minutes. Look how detailed these things are. And that's how long it took. They had to sit there while it was booting up. And at the end of their shift, they would clock out, and then sit there while their computer shut down, which took between 4.75 and 7.75 minutes. The question is, and there was a collective action, class action brought under the Fair Labor Standards Act, federal law, claiming that the time spent turning computers on and off was compensable. The district court granted summary judgment in favor of the employer, reasoning that turning a computer on and off was not part of the employee's principal activities. Therefore, it wasn't compensable. The Ninth Circuit looked at it and said, well, the district court was correct that booting on and off a computer was not a principal activity, but answering customer calls and performing scheduling tasks was. So turning on the computer was part of that process. You couldn't do your job until you turned the computer on. But because the employee couldn't perform the job without the computer. But turning off the computer had nothing to do with his job or duties, and therefore was not compensable. So turning off was not integral and indispensable, but turning on was. What's interesting about this is it is Ninth Circuit still insane. We had a year or two ago a case dealing with the donning and doffing of work clothing or equipment before you go after a shift. So you go to work, you'd have to put on special uniforms, special safety gear, special outfits. That time was compensable. And then after work, they'd have to take all that stuff off. Well, was that compensable? And California said, yes, putting on the clothes that the workplace was and taking off workplace was. So you didn't clock out until after you took off all the clothes and put on your street clothes, and you clocked in as soon as you walked in the doors. This is different. So I don't see the difference between turning a computer off and taking off the work clothes. But that's how it is here in California. So it's interesting. So it's important to know that if your job requires booting up and turning off computers. So now we can answer questions. So Ashley.
Thank you. Thank you, Roy and Chris. That was a great presentation, very informative. We do have some questions in the chat. First, can you please touch base on prevailing wages?
Is there any more details? Prevailing wage is very detailed and very complex. If there's no more well, let me ask you, is there any additional details to that question?
It's a very general question.
Generally speaking, I can take that for now. Generally speaking, prevailing wage is extremely nuanced, and I believe it's on the DIR website, but if you Google or search DIR prevailing wage, you'll get a list that's literally pages long, and it depends on what type of prevailing wage work you're performing. And as you open that or you scroll through that list, you'll click on, I did one that was pouring concrete on state highways. And you had to look to see which category of prevailing wage they qualified for. You click on that link, and then it would open up an entirely different and more complex matrix of what was required to pay, including not only the higher rate than your typical rate on a non-prevailing wage job, but the fringe benefits, which I believe there's 6 of them. I can't think of them off the top of my head. And again, they vary depending upon the field or trade that you're doing. But prevailing wage is very complex. If you have a specific issue or you have questions about how to properly do prevailing wage, you should consult with an attorney, or there are actually prevailing wage experts out there. But it's very complex. It's very difficult to do. It's very lucrative if you can do it right, but the checks and balances that come along with prevailing wage projects and pay is very detailed. So again, without knowing more, just take a look or start with the DIR, the Department of Industrial Relations website, and prevailing wage and all the different categories you can find.
It usually applies to the construction industry, right?
Typically, yes.
It's not office or clerical or
Correct.
service, right? So it's a specific, it's industry specific sort of thing. Yeah, if you have specific questions, we could certainly answer those.
But again, and Roy's right, it is typically that, but picture the construction situation where one guy drives a truck, one guy loads the truck, one guy unloads the truck, one guy pushes the slurry or the gravel or the blacktop onto the actual road. Another guy standing on the back of the truck telling the guy in the truck when to go forward 6 inches. I mean, and each one of those categories is treated differently. So it's extremely detailed and nuanced, but yeah, consult with a professional or have an in-house professional if you're lucky enough to have one.
Thank you, Chris. Next question, does the annual pay data, does that apply to employers with 25 employees or only more than 25?
The pay data requirements are employers who have 100 or more employees.
Okay, thank you for clarifying.
Larger employees.
Okay, with regard to Pay Transparency Act, if an employee requests to see the company's pay ranges, are they required to show them the pay ranges for all positions or just the position of the employee?
Just their position. So I'm doing office administrative work. I want to see the pay scale for office administrators. So you don't have to show the pay scale for everybody.
Thank you, Roy. The next question, they say, thank you for mentioning that employers don't need to pay for the new 4 holidays. Are employers obligated to pay for time off for any other federal or state holidays?
No, you're not required to pay. You're not required to pay people to not work, and you're not required to pay them at a higher rate. If you're open on, let's say, Memorial Day, Veterans Day, Christmas Day, think of the Amazon delivery trucks. Those guys are working 365 days a year. If they're working, they still get paid their regular wages. You, of course, are entitled to, or can be a nice guy if you want. Be careful where that gets you as an employer in California, but you can pay them a higher rate, but you are not obligated or required to pay them to not work or pay them a higher rate if you are open and they are working.
Now, the key about these holidays are you don't have to pay, as Chris said, but if somebody wants to take off Juneteenth, you can't discriminate against them for doing so. They can use their sick pay, they can use their personal leave time to get off vacation pay, but these aren't required off. It's just things that we do. And it's interesting how many employees actually believe that if they work on Christmas, they get time and a half. A number of companies do, but not required. That's an interesting point.
And the thing with the 4 new holidays that are recognized, and Roy hit it on the head, and I should have been clear about that, but it's that you can't discriminate. If someone says, I want to take off the Lunar New Year or Genocide Day or Native American Day, you can't discriminate against them and take an adverse employment action or fire them. If they are allowed to use their accrued vacation time, if they don't have vacation time, they can take a day without pay, but you can't discriminate against them for observing those holidays, but you're not obligated to pay them if they observe them or take the time off.
Great, thank you. You had mentioned 401k. They're asking, is this effect not in effect until December of 2023? The 401k change.
Before, I believe, if I'm correct, I believe it was July 1st of last year, July 1st of 2022, you had to have a retirement savings plan in place for all employees. The Cal Savers is, and I'll admit, I'm not extremely well versed in Cal Savers yet. I've handled more employers that have the 401k plans, but I think this is setting up a methodology where the employees can directly have access to a Cal Savers plan, and it has to be automated or in place by, I believe it was the December of 2025, if I recall correctly. So the answer is nothing, neither applies to this year, 2023, but you do have to have some plan in place. And again, I can handle a more specific question if they want to call us or email us, or you can look into it, but it's the Cal Savers plan that's to be in effect with the direct deposit function, I believe is what it was.
And it's important to note that this is at really no cost to the employer. It's not like there's no matching, there's no contribution by the employer. It's strictly to give the employees an opportunity to put away some money for their retirement. Most payroll companies will have this all set up. If you can ask your payroll companies to do this for you, you can talk to financial advisors. There are people who kind of handle these things, but we can certainly help comply with the law. But it is no cost to you. It's not a great program, and employees aren't going to get rich from it. It's not as valuable as 401ks and so on, but California's decided it's best for every employee to put away some money if they can.
And the specific language is that if you don't offer employer-sponsored retirement savings programs, you must have a payroll deposit retirement savings arrangement in place by December 31st, 2025, so that the employees can participate in Cal Savers.
Thank you. The next question is about AB 2068. Is there a threshold on how many people need to speak a language other than English? So for example, if the workplace is 100 employees that 4 speak Mandarin and 1 speaks French, do you still need to post in Mandarin and French?
I'd say the short answer is yes. I mean, yes, and especially if it pertains to the Mandarin or French speaking employees. And I don't mean that that's a carve out. If an English speaking employee was injured, if you're talking about the Cal OSHA part or any other notices, you can't unfairly alienate or eliminate or discriminate against one person, be it the French person, the Mandarin person, or the English speaking people. So if you got multiple languages, and again, you also, you can ask your employees if they, I won't say most, a lot of employees, a large number of employees speak 2 languages. And if it's something as a notice that goes out to the company and they can read English fine, you're not obligated to put it in Mandarin or French in the example. If your employee from France speaks fluent and reads fluent English, the English posting will be fine. This is more of a situation where you have employees that don't communicate with you in English, and when you do talk to them, you have either an interpreter there, or you yourself are bilingual and you speak them in a different language. So again, I would ask the question to the French employees or the 4 Mandarin employees and say, can you read this, or do you have any problems with this? And again, specifically with the OSHA one, that's OSHA's burden. You can make them jump through another hoop and ask for all 3 languages. But yes, yes, you should post in all languages. No, it doesn't matter if it's just 1 French employee, 4 Mandarin employees, and 95 English speakers.
Thank you, Chris. Any new rules regarding personal cell phone usage during the job? Anything to add there?
Well, there is actually. Let me answer that and Chris to chime in. Most companies have cell phone policies. You're not supposed to be on your cell phones during working hours. Leave it away, put it in your desk. You're not making personal calls. However, there is new laws now dealing with that, where you have a right to use your cell phone to call if there's an emergency. Gotta get a hold of your family, be notified of an emergency. There's a workplace emergency. You can use your cell phone for that, regardless of the policy. And you certainly can prohibit generally using cell phones while your employees are driving for the company, again, except for emergencies. That's an important policy.
Yeah, and the other thing that employers sometimes, because of the day and age, and we're sitting here giving a presentation with cell phones on the desk, and there's emails coming in, there's text messages coming in, and depending upon the nature of your business, text messaging it's almost trumping email these days, and you'll email or text an employee, hey, can you cover John on Tuesday, or when will you be back from lunch, or can you pick up something on your way back? That's the employee using his or her cell phone for the benefit of the company, and they are entitled, this is not a new law, but they would be entitled to use for that cell phone. So when you ask, are there additional rules or laws that pertain to personal use of a cell phone? Yes, there's a handful of them, but again, can your employee sit in his or her office and scroll through Instagram or text their buddy or buy Dodger tickets or whatever it is online? No, they can't do that if you have a cell phone policy that prohibits cell phone use for personal use. But again, if they need to use it in the case of emergency, that's the new law, where natural disasters or criminal acts are occurring. They obviously can use them. You almost want to encourage them to use them. And then otherwise, even when you text an employee, it opens up a lot of doors. If you text an employee outside of his or her shift, they go home at 5 o'clock and you text them at 6:30 at night, hey, can you do this for the job? Can you open up the door early tomorrow morning? Can you cover a shift? I mean, arguably, I've seen it, and it could be, it's a live claim. They're working after hours. You owe them for the time spent replying to that text message. So there are a lot of rules about that. If you have cell phone policies in effect right now, take a close look at them, consider revising them. You're going to probably want to revise them if you want to add this additional stuff about natural disasters and criminal acts. But be careful on the cell phone usage. It's taken for granted how much we use our cell phones, but it is compensable time. And if they're using the cell phone, the benefit of the business, they're entitled to a reasonable compensation. In other words, a reasonable portion of the cost of their cell phone bill per month.
Well, a lot of companies are doing, I'm sure a lot of you are too, is to have a work cell phone. The company provides a work cell phone. That's the one you use, no personal texting or emails on that one. That's just for work. And you have your personal one. So you can monitor that they're not spending a lot of time on personal stuff on the computers. So it's an important one. It's a policy to be looked at and revised if necessary in the handbooks.
Okay, thank you. There is a question about the mandatory salary reporting. Where is that to be reported? Is that something we should email the answer to, or do you have that available?
What was that? Mandatory?
Mandatory salary reporting?
Oh, the pay data reporting. Yes, if you have 100 or more employees, you probably should be knowing to do that already. Your payroll company helps you do that. But there's forms that you have to fill out and send into the government. Yeah, and that's something you do with pay data reporting. If you have 100 employees, been doing it, we can help you get the form if you need it, help you fill it out. It's not all that complicated, but it's something your payroll company will help with. HR does. It's just it's a government form.
Okay, and the minimum salary, is that employees regardless of the business size, or is it large businesses?
Regardless of the business. If you want to have an exempt employee that you're going to pay $64,480, whatever it is, just have one. If that person truly qualifies as exempt, not subject to any size. Same with the $15.50 minimum wage. It's now all sizes. We used to have the distinction between large and smaller. Now it's everybody.
Great. Only two more questions. Back to the posting. Is an employer allowed to ask if a person, what language they understand? So can you say, do you speak English? Do you speak French? Can they ask that question if they don't volunteer?
Well, the answer is yes. However, obviously the context and the situation in which that question is asked and even the way it could be phrased needs to be done properly. In other words, you can't make a snide comment, what's the matter, you can't read English? I mean, that's not going to fly. On the other hand, if you're talking about either training, the details of training someone for their job or explaining technical aspects of the job or difficult language, or you're reading, oh, our lawyers just told us this new language says that an aggrieved employee, blah, 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 the quoted language. You can obviously ask, would you feel more comfortable hearing this in Spanish or Mandarin or French? And if so, hold on, I'll get an interpreter in here, or we'll take the necessary steps. Most of you know your staff. Most of you know whether your employees can communicate in more than one language. So again, as long as there's not any sort of discriminatory intent, or they can be inferred as being a discriminatory comment. What, you can't read English? You can't say something like that. You can say, listen, we're going to train you on how to perform your job and what our expectations are for you. Would you feel more comfortable if I had someone speak Spanish and explain that to you, or French or Mandarin or anything else?
Okay, great.
You can't have an English-only policy. You can't prevent employees from talking to each other in their own languages. You can say English for those dealing with customers and English-speaking customers, but they got to be careful about that. It is a First Amendment constitutionally protected right to be able to speak your own language. It's national origin rights, and there are civil rights laws. So you got to be careful about that. So you wouldn't necessarily ask somebody, but when they apply for a job, you can ask, what language do you speak? And you generally know.
But the last point on that is just, when we do handbooks, we always ask, do you have Spanish-speaking employees? Do you do a Spanish version of the handbook? Because again, if and when you have to deal with litigation, you don't want a plaintiff to say, oh, well, my first language is Spanish or Mandarin or French, or I speak the language fine, but I can't read a 72-page manual containing all these policies and technical terms. So You know, you should know your workforce, and you can clearly ask them, would you prefer that this is in a different language? And if so, you need to provide that posting or that information to them in their preferred language.
Yeah, we'll do the handbooks in whatever language they need. We have a service that can do that for us.
Thank you. If an employer offers a contribution retirement 401k, are they required to offer the state plan as well?
No.
No, if you have an employer-sponsored plan that you've set up, whether you're contributing or not, you don't need to do the CalSavers plan.
Okay, great. That concludes our questions that were in the chat. I'm sorry, in the Q&A. Ashley with the Ventura Chamber will send out an email to everyone that registered, which will include the PowerPoint and a link to the recording of this presentation. And we thank you all for joining. We hope that you join our seminar next year. Thank you, Roy and Chris.
Thank you, Ashley and Angela, and thank everybody for attending.
Thanks a lot.
Thank you everyone for attending. Thank you.